Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Hello and welcome back to Arbitration World. My name is Declan Gallivan and I'm a Senior Associate at K&L Gates. This is episode 2 of the mini-series where I sit down with two leading arbitrators, Lucy Greenwood and Klaus Reichert, to discuss issues that arise in the arbitration process. In the mini-series, we have a discussion about the different stages of an arbitration and what changes can be made to lead to a more focused, efficient and productive process. In episode 1, we focused on PO1 and procedural meetings. Today, we discuss document production and witness statements. But before the discussion starts, I'm obliged to note the following. This podcast series is limited in scope as appropriate for a general audience and applicable time constraints. The information in this podcast series is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of the specific facts of a given case, and all speakers appear in their personal capacities, and any views or opinions offered are those of the relevant speaker alone, and do not necessarily reflect the opinions or views of K&L Gates LLP, K&L Gates Straits Law LLC, or any other entity or individual. Klaus, let's turn to the document production phase. In my experience, this is a stage which is often the subject of complaint, particularly in large complex arbitrations. What are the common issues that you see arise from this stage, and how do you deal with those issues?
First and foremost, I think the IBA rules have now become so well embedded that people now defer to them in almost any case anywhere in the world. So that relevant and material to the outcome of the dispute is the standard that everybody talks about. But one of the things that the IBA rules has not achieved is it has not achieved a narrowing of document production. So if one was to go back in time to 1999, early 1999, before the IBA rules were adopted, one would ask whether or not there was less document production then rather than now. And I fear the answer is, I'm afraid there's considerably more now. And I think this goes down to the ingenuity of counsel in terms of coming up with suggested categories. And also it's going to accelerate even more when you look at the type of AI products that are available to assist counsel in the interrogation of files and identification of areas to explore. So therefore, the number of categories of documentation, which could conceivably, by the ingenuity of lawyers, become relevant and material. I'm afraid that is, to my mind, one of the great issues facing the practice now, because any of the client side people, and I'm not talking about in-house, I'm talking about the people who have to write the checks or make the payments for these processes, namely chief financial officers or chief operating officers of companies. They're finding this really quite bewildering that so much money and so much time and so many resources are being spent on this area. From an arbitrator's point of view, one often wonders is what use is being made of all of this? You see halfway through a briefing process where there's, with considerable solemnity and force, parties say that X and Y is crucial for the outcome of the dispute and relevant and material. And then these documents seem to just simply vanish into the ether. One wonders what it was all about. So I think this is an area where the focus needs to be brought, not just into fairly mundane 101 stuff like getting parties to meet and agree and so on and so forth. That's going to continue. I think what needs to be looked at is a much more rigorous approach to the foundation of what document production is all about, namely from an evidential point of view, and really making parties think about what it is that they want from the other side and why do they want it from an evidential point of view. If we have time, we can get into the specifics of that. some of the things that I've seen and used, but I believe that this is an area of real need for a ground-up review of why document production is used and how it is used.
Thank you, Klaus. I think it would be interesting to discuss some of the specifics. But before we do so, can I bring in Lucy? Lucy, what's your views, and do you share Klaus's concerns?
I do share the concerns, and I'm very much of the view that this is an area that is ripe for deep structural reform of the process. And there tends to be an assumption that on every international arbitration you will have some form of document exchange, and I think that needs to be questioned. Completely agree with Klaus. You get these representations of the cruciality of a category of documents and never see them again. The flip side of that, I think, is that arbitral tribunals are often not completely in a position where they can adequately address the representations that are made to them that this category of documents is crucial. Even the most engaged, well-informed, well-read tribunal that's read every single word that has come in from the parties won't be, I suspect, really far enough up the learning curve. They'll be as far as they've been taken, but it's still, they will not know those cases inside out in order to properly answer the question whether the category of documents is truly crucial to the dispute. I'm using crucial, appreciate it, the standard is material and relevant, but, let's try and move away from that and say, do you really, really need this? So I think tribunals naturally err on the side of being quite conservative if there is a concern. Well, we don't really know, this could be material, and you grant it because you don't want to be in that position where counsel says at the hearing, well, we asked for these documents and the tribunal denied them, and your sort of heart sinks. So it's a natural tendency, I think, particularly for lawyers, to err on the conservative side. And the result is that you are getting these orders for extensive document exchange. So it is a real problem. There are things tribunals can do, tweaking around the edges to sort of rein in excessive document production. Again, you can set some expectations in the first CMC and thereafter, and certainly an active and engaged tribunal will try and do that. But I do tend to agree with Klaus that this is a fundamental problem that needs fundamental structural change.
Klaus, what's your reaction to Lucy's comments there? And we could go back also to your specifics.
I see that we're aligned on our concerns. Let's go back to what it is that we're actually doing. And this goes back to the point I made early on about CMC and interrogating people about what it is that we're doing. And if one considers what is the exercise that everybody's engaged in, a tribunal will want to know what happened between the parties. And those are the facts. And then they'll want to know what is the applicable law and the content of that and how the law and the facts marry together. Now, depending on your legal background, there are various ways that you arrive at the same outcome, namely the disposition of the prayers for relief. But fundamentally, what document production is an evidential matter. It goes to whether or not X or Y happened or didn't happen, or happened in a particular way, or had a certain motivation. If, for example, good faith is part of the legal analysis. And this is where I think parties need to focus. First and foremost is what actually is the fact that is at the background of a document production request. What is it that one side says happened, that the other side says did not happen, or did not happen in that way, or there was a hidden motive behind the happening of that fact? These are just random examples. And then the next question would be is, if there is dispute about a certain matter of fact, the parties will marshal their own evidence that's available to them in respect of that matter of fact. And the question then would be is when a party sits down, and particularly the counsel who is presumed to have expertise in the area of forensics and evidence will say, what do I need now to prove the fact in the way that my client wishes it to be established? That will be done on the basis of the documents I have available within our own patrimony of documents, or it can be proven by the witnesses I have available to me. Those are generally the two routes for proof. Then there's the third route, which is maybe the other side have documents which are not available to us that would assist in proof of this matter. So far, so good. It's the sort of thing that anybody who's actually done even the most mundane civil trial in a remote country courthouse will know that. You don't need to dip into any form of advanced textbook or advanced learning process to know that. So therefore, the question would be for counsel, is what I have available to me sufficient to establish the fact, the disputed fact, in my client's favor, or must I seek further documents which I believe the other side have? And I think if you start from that premise, that actually puts a far more rigorous evidential exercise into document production, because almost anything could be made relevant and material if you are have sufficient ingenuity and with your writing style. But if you approach it from the basis of what is it that you must do, and having given consideration to the evidence already available to you, I think that's a much better starting point.
Thanks, Klaus. Lucy, do you see that rigorous evidential exercise that Klaus is suggesting to combat some of the concerns that you've raised, for example, of the tribunal not feeling confident to decide the document production requests at an early stage?
Yes, I absolutely agree that is the fundamentals. There should be the fundamental starting point for every document request that's made. Unfortunately, again, it's perhaps a lawyerly thing of being very conservative. We see that counsel are not necessarily following that approach in the rigorous way that Klaus described.
Before we move on, Lucy, do you have anything else to say on document production or ways that you've effectively tackled some of the issues sitting as arbitrator, or shall we move on to witness statements?
I mentioned slightly tinkering around the edges as a tribunal, and I do think it is incumbent on an active and engaged tribunal, which every tribunal should be, frankly, to roll up their sleeves more than perhaps is normally done in relation to document exchange. So there are levers that you can pull. There's setting out very clearly in the procedural order what you expect to have happened before anything even comes to the tribunal, setting out clearly that the tribunal won't, for example, reformulate requests, because again, that focuses the mind. It puts counsel on notice that they've got to do their best to get voluntary production, and sometimes if both sides are asking for a lot of broad categories of documents, then it may well be that they have to reach some kind of agreement on that. So I'm certainly quite robust in my procedural orders in relation to document exchange, and I have found that works in terms of limiting the number of requests that actually make it to the tribunal for consideration, to try and bring the parties a little bit more together on this.
Thanks very much, Lucy. Let's move on to witness statements. Lucy, what are your biggest concerns about current practice around witness statements and your most common gripes?
Witness statements are a real challenge. They're a challenge culturally. I touched briefly on earlier about the cultural differences that you see in international arbitration. They're a challenge procedurally, I want to say, because all too often you find that witness statements are effectively another submission. often even duplicate quite worryingly closely the written submissions made by counsel. And if they do that, they do not assist the tribunal at all. So I think there needs to be a refocusing of attention on the witness statements and on the fact that they are there to set out the witness's personal knowledge of particular events. They almost fill the gap that might be left around the contemporaneous correspondence, for example. See, contemporaneous correspondence is an incredibly strong piece of evidence. There may be a need for personal knowledge of a witness to fill a gap around something that hasn't been contemporaneously documented, like a meeting, for example. But I think what we have increasingly seen over the last 20 years is witnesses trying to tell a story which they think may help the tribunal, but in fact that story is more properly told throughout a reference to contemporaneous documents, and the witness is there to assist the tribunal where there is particular events to which that witness can speak. And I think that has been forgotten, or certainly pushed to the back too much, and it needs to come front and centre in terms of how a witness can properly assist the tribunal.
Klaus, do you want to chime in there?
Yes, I believe that witnesses and witness statements need to undergo the same rigorous review in terms of what it's all about as document production. Because in the end, what is the purpose of a witness statement and a witness coming to testify to the tribunal? It's a matter of proof. And a fact witness, for example, what business is it of theirs to advocate a particular legal theory or anything like that? The witness can only speak to matters of fact within their knowledge. And I often am reminded of a phrase in Yes Minister, the immortal TV British comedy about politics in the 1980s, which said the whole point of inquiries was to uncover a great mass of no evidence. The uncovering of a great mass of no evidence is all very well if you like that sort of thing. But from a witness statement point of view, why does a witness have to go over areas that are actually perhaps not in dispute as to their occurrence? Now, there may be quite important elaborations about certain aspects of areas that are not in dispute, particularly when it comes to, for example, certain motivations about business decisions depending on the legal system involved. But beyond that, the witness has no need to effectively repeat and cumulatively state what it is already not in dispute as a matter of fact. Now, there's all sorts of other things rolling around the world of witness statements about witness memory. It's interesting, of course, that the world of arbitration has only recently alighted upon witness memory. But as anybody who might have some knowledge beyond the field of international arbitration will know, that witness memory has already been extensively researched since the 1970s by Elizabeth Loftus in California. And there's quite a lot of learning far beyond that which is already in the world of arbitration in relation to witness memory. So to my mind, the greater impact of a witness statement and the function of a witness statement is really to focus on, from an evidential point of view, why am I reading this? What areas of proof am I being assisted with this witness statement? If I'm simply reading things that I've already seen in the submissions, it's of no great impact. It's just simply sitting there. And one wonders why on earth that this person has filed a witness statement.
Can you think of anything in sitting as an arbitrator that's particularly resonated with you that someone's done, a witness has done in practice in terms of their witness statement? Or is it more a sort of restructuring of how we approach the fundamental purpose?
I think, again, it's sort of asking that, taking the time at the outset to ask the question, what do I need to achieve by this witness statement? And often that little moment of time is not taken. So there's an assumption, A, that there's going to be a witness statement, and B, it's going to be long and tell the story as I previously mentioned, or it's going to mirror the submissions, which is deeply unhelpful. I think if you pause and actually ask the question, do we need a witness statement at all? And that has two prongs. Do we need a witness statement from this individual? Or is there a way that evidence can be given without a witness statement? And this is slightly drawing on my US experience, where occasionally you have direct evidence in chief, where a witness will come and they will give their oral testimony, which is effectively what a witness statement usually replaces, that evidence in chief, that oral testimony. But when you have well executed direct evidence like that, where you're eliciting evidence from a witness, it can actually be much more helpful to a tribunal, because obviously a witness can't recall what the submission said, or can't recall all the emails that a witness statement wouldn't necessarily reference. And by definition, you are drawing on that witness's personal knowledge, regardless of the fact that they may have been well prepared for that oral testimony. So I'm certainly not advocating moving away from witness statements in international arbitration. I simply mention this to point out that there are other ways, and if done well, like anything, I've seen them be quite successful and quite helpful within that context. So I think it does come back down to the fundamental question of what is the point of all this? What are we trying to prove by bringing this witness forward?
Thanks, Lucy. Thinking about how you balance a sort of party's right to present its case as it thinks fit with procedural efficiency, are cost penalties a way to address the practices or the problems that you two are describing? Klaus, what do you think of that?
I believe it's one of those things that everybody says. It's certainly trotted out at many arbitration conferences. Whether it actually results in a modification of activity during the course of an arbitration, I'm not sure. I think certainly from my own observation and from discussing this very issue with colleagues, parties are very much focused on the task at hand, and when they are at daggers drawn, as very often is the case, whether or not something is going to trigger a cost penalty some way down the road, off in the future, is not foremost on the minds of parties and their counsel. I think it's also relatively rare that a tribunal will come out and bluntly say in an award that a party has behaved badly, and therefore, even if it has prevailed, it's going to be massively docked on costs or get no costs at all. That, to my mind, is a rarity, because in the end, experienced tribunals who have themselves been in the trenches as counsel are less inclined to second guess the decisions in real time in the heat of battle taken by counsel and parties, because they've been there themselves. And an expectation that counsel will crisply identify and carefully only use those points which will work is an exercise in perfection, or the expectation of perfection. And as we all know, there has never been a perfect counsel. No such person has ever existed, because perfection is inherently unavailable in the human condition. So this is why I think tribunals tend to be relatively restrained when it comes to scourging counsel and parties in costs. And experienced counsel know this, but it's very difficult to then second guess afterwards whether or not something merits mention. And in my own practice, I could probably count on one hand the number of times that I or my colleagues on a 3-member tribunal have really gone out of our way to say, this was bad, you shouldn't have done that, and therefore you're going to suffer the consequences.
And just to come in on that, in terms of sanctioning and costs, there's a distinction between the ability to sanction costs throughout the arbitration, which a tribunal has that within its discretion, but is very, very unlikely to act upon it, in my experience anyway. And then the ability to sanction certain conduct in the award. But I think the important point, and it's slightly building on the point that Klaus was making, is that we as arbitrators are very conscious that we only are party to that which comes over the table to us. And you are very conscious that you do not know why a party might be putting a particular point, or what is going on the other side of the table in terms of the relationship between the underlying client and counsel. And it is not our role to look into that. So we really need to be very aware of that sort of divide, that we only see what comes across the table to us. And I completely endorse Klaus's point about not in any way trying to second guess the reasons why a case is being argued in a particular way, because there may be very, very good reasons at the client level. Maybe negotiating tactics, maybe ongoing business relationships, maybe all sorts of things going on there that we neither know about nor have any right to know about. So I think that the cost sanctions issue is a really challenging one. And to be honest, I don't see ongoing sanctions and costs coming up that often in my matters.
Thank you very much, Lucy. Thank you very much, Klaus. That's it for episode 2 of this 4-part mini-series. Please do join us for episode 3, where we move on to the hearing stage of the arbitration process. And it wouldn't be a podcast in 2025 if we didn't mention AI. Thanks again for tuning in.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.